Greetings from Washington, D.C. It's a sunny and cold and most of all quiet day here. No exciting activities. And I hope you all are doing well. It's good to see. I'm glad you've all joined for today, where we're going to spend some time talking about advanced sweepstakes and promotions. A lot of you have joined me in the past to talk about the basics. And so I wanted to take this session to maybe talk about some of the topics that I get questions about a lot, that are a little more complicated, and we can spend a little more time discussing. So let's dive right into it. And I have to find the arrows on the screen. So here are some of the topics. I'm not going to spend time obviously discussing them now, but things like what is non-monetary consideration, what types do we need to worry about, or what types of special contests or sweepstakes, what do we need to think about when we're having an employee sweepstakes, or really what about those UGC promotions anyway? What do I need to be worrying about here? What is a surprise and delight promotion anyway? My people keep coming and asking about them, all those sorts of things. So that's what we're going to be talking about today. And yes, the deck will be available afterward in response. I will try to keep up with some of your questions, and some of them I may get to at the end, and some of them I may have to just follow up with you afterwards. So ask away, and if you don't get answered right away, we'll get to them later. So just as a note, sweepstakes are still heavily regulated. The FTC brought several cases in the past year or so. We saw one, FTC versus traffic jam events, that was specifically associated with COVID. There was a scheme where someone was sending out prize mailers that were telling people how to obtain their federal COVID-19 stimulus benefits and then sending them onto a used car sale. So maybe not really about a prize at all. Next Gen, which involved the Missouri Attorney General as well. You know, the states, of course, are active here. Mailers informing consumers they had won, but they'd need to pay to collect a prize, which of course involved consideration. The mailers also, there were newsletter subscriptions or games of skill that required you to pay and try an unsolvable puzzle. This was a huge settlement, $21 million in cash, personal property, liquidation of the companies. Altogether, it was a $114.7 million judgment. So you're seeing real cases here. There was actually one with the Indiana Attorney General where it was a case where there were mailers sent to consumers involving ads for car dealerships that represented they were a free gift, which of course is another type of promotion, but that there was chance involved. They might win a prize, and there was no such thing. Every recipient received the same combination of symbols representing they may win a prize, but and a very large prize, but then the prizes were substantially smaller than what was advertised, and they had to pay taxes to receive the prizes. So again, consideration, a payment, and deception all wrapped into one big friendly ball. So you know, these are going on. You tend to see with the FTC bigger scams involved, but the difficulty with these, with all of these sweepstakes and contests is, A, you still get investigations, and when you tend to see problematic sweepstakes that get the eye of a regulator, they don't just look at your sweepstakes. They tend to look at a lot of different types of, you know, advertising. And so once they start looking, you can find, you know, issues with influencers, issues with general deceptive advertising, and you just don't want a regulator looking up your skirts. So going to the basics for just one or two slides, we want to go back to how we take a look at prize promotions. A client comes to you, they have a great idea. The first thing you want to do is take a look at whether we're talking about potentially an illegal lottery. A lottery, of course, has three elements. Prize, somebody's giving something away. Are the winners determined on the basis of chance, a random drawing? Alternatively, is everybody getting something, a free gift? Or is there some sort of skill involved, so there's no chance involved, in which case you're talking about something that's more of a contest or a game of skill. Most important and the most difficult determination in this analysis tends to be, is there consideration involved? That's sort of the third leg of the stool in the lottery analysis. If there's prize, chance, and consideration, then you've got a lottery. If you can remove one of those, then you have a legal sweepstakes, contest, or free gift. The reason why consideration is so difficult, of course, is because while it's easy to ascertain whether there's a purchase or payment, at least typically, that issue of non-monetary consideration is much trickier. It's not illegal in all the states, and the definition varies substantially from state to state, and we'll talk about that in a second. In terms of, if you do think that you have a regulated promotion, a sweepstakes, contest, game of skill, the types of requirements that are then triggered are things like rules. You need to make sure that you have official rules, that you're making appropriate disclosures in your advertising. What goes in your rules is generally very specifically regulated under state law, or many states have very specific requirements for what goes in there, as well as things like the postal statute. If you've got a sweepstakes is going to be distributed by mail, or the FCC Act for something that's going to be on radio or TV. So these laws say things like you must have eligibility requirements or prize details or start and end dates in your rules, as well as material terms disclosed in your advertising, all your advertising for the sweepstakes. The Florida Game Promotion Regulation, the site is given in here, actually has a very good rule of thumb for what should be in advertising. It's one of the most specific about what are the material terms disclosures for advertising. Although a couple of states go further than them. And so Florida says really you should have odds, eligibility, deadlines, and sponsorship information. But then New York, for instance, wants more information about the prize than Florida asks for. Some social media sites also have their own rules, and we'll go into that a little bit later. And then there's the sort of good to have or good idea to have for what goes in your rules. Things like publicity and liability disclaimers, the right to modify, a link to your privacy policy that's really protective of you as the privacy, or rather the sponsor, rather than required by state law, because of course you want to make sure that you are protected if something goes wrong. In terms of what these rules should look like, or really what the advertising disclosures should look like, you really want, generally, it's a good idea to follow the rules for what is clear and conspicuous disclosures in advertising. The Federal Trade Commission's 4 Ps, prominence, proximity, suddenly blanking on the 4 Ps, but if I think I've got them in my slide notes, we can put them there. But in any case, the 4Ps and the .com disclosures provide a good rule of thumb for what is clear and conspicuous. The .com disclosures, of course, are guidance from the FTC that indicates what is clear and conspicuous in online advertising. And they say things like, gee, you shouldn't have to scroll down in order to find important disclosures, or what you're looking at the important disclosure should not be unduly far from the main claim, things like that. So you can look to those for what is what the important disclosure is. In terms of registration and bonding, there are 2 states, New York and Florida, that require registration and bonding for sweepstakes where the total prize value is more than $5,000, and then $500 triggers the registration requirement for Rhode Island when you're talking about a sweepstakes that is run through retail establishments. In terms of what that means, I can tell you we've had conversations with Rhode Island regulators, because I sometimes get that question, where they've really indicated an interest in more in brick and mortar stores when you're talking about something that's advertised or run in retail stores as opposed to online at this point. That's sometimes a question you get. Ultimately that's a judgment call. But that has really been the main regulator's interest when it comes to that registration requirement, not something that is strictly online. Then there's a registration requirement for skill contests where you have a purchase requirement in Arizona. And we'll talk a little bit about international later, but there can be registration requirements for other countries if you're doing something that spans multiple countries as well. Then, of course, some states require posting rules or winners lists. So that's relatively easy to do online, but it's a little trickier when you're talking about something that, again, is being run in store. That's particularly important if you're running something that has been registered or bonded. Oh, I am rolling on here a little fast. Okay. So non-monetary consideration. This is something that comes up a lot in discussions. There's always been this general view that, oh, there's not that many non-monetary consideration cases. We shouldn't be that worried about it. But in fact, there's some private litigation that's gone on, and there's increasingly a concern with sort of some of the more sophisticated requirements that we're imposing on entrants nowadays, with things like, oh, you have to attend a lengthy scavenger hunt, or you have to submit a video and then we may use it online, or the like, as to whether these types of requirements that are being imposed on entrants may constitute non-monetary consideration. I think this was the issue of consideration came up probably most glaringly in some cases a few years ago that were brought against the producers of some of the shows like Deal or No Deal or American Idol, where there was a premium text entry requirement where people had to were invited to enter a sweepstakes through using a premium text message. In that case, there was a clear monetary consideration requirement, but since then there's been this question of whether a regular text message would be consideration or not. So the issue sort of boiled down is that we know that monetary consideration is going to be problematic because of this three-legged stool we've talked about of a lottery, of the requirements in a lottery. But non-monetary consideration in certain states, which are listed in this slide, may render a promotion illegal as well. So the issue is that if there is a substantial requirement, the expenditure of substantial time or effort required, then that can be non-monetary consideration. And indeed, in some states, there's older case law that says that even the sort of traditional contract consideration, where there's a benefit to the sponsor, can be consideration as well. A lot of these cases are older, but there are some attorney general opinions that run sort of more recently that also opine on it. So you've got opinions that say that things like requiring somebody to come in and come to a location multiple times, or to participate in a scavenger hunt, or things like that, are in fact consideration. So there is some guidance out there. There is really no good guidance on the issues beyond perhaps, an assistant attorney general opining on, informally on the issue of like text messages, where we have had some assistant attorney generals who've said, well, text messages could be consideration because some people are still paying for them. There's the comparison to stamp, but there actually was an effort years ago by actually what was the Promotional Marketing Association, and is now, after a couple of different iterations, become part of the ANA, to get an opinion that a stamp is not consideration. So we haven't had that with text messages at this point. So text messages still sit in kind of a zone. There is an opinion out there that says that watching a TV program or listening to a radio program so that people will get the answer to a question is not consideration. But I'm getting questions about sort of, and this is a common one, about surveys. The general rule of thumb there is, gee, you can't ask somebody to answer a very long survey versus a few questions. And there's no sort of hard answer here, but, asking people to commit a few minutes to answer a few questions is one thing. A long survey versus, where people are, say, giving up lots of personal information is certainly going to be more problematic. Frankly, at this point, I might answer 2 questions. I'm not going to answer lots of questions for simple time reasons. And I think you need to be thoughtful of people's time that way in any event. There's no hard answer there. In terms of personal data, I think that we need to be thoughtful about the fact at this point that we've got regulators clearly and legislators clearly saying that personal data is valuable. However, there's also all sorts of opt-outs being offered. So say in CAN-SPAM, you are allowed to opt out of receiving emails the minute you receive that first email. So that's, one consideration. I'm aware of no enforcement with personal data. However, there's extensive requirements, with respect to compliance when it comes to personal data. I'm trying to answer a few questions that are coming up here. So we're a little more scattered than I might be, but these are questions that I'm getting. I've got the question that, is an app download or the requirement to use an a smart device okay. With the app download, if the app is free and available to all, as I said, that's probably relatively low risk. With the smart device, I think at this point, people feel like that's probably low risk as well. The interesting thing, and this is going to come up in discrimination in a minute too, is we've seen some complaints out there from senior citizens about high-tech promotions and whether there's discrimination against seniors on that. There's been no case or activity. I've seen attorney generals who've gotten those complaints, received responses, and failed to take action. But this has been something where there have been complaints about the use of entirely smart promotions. And, that's another consideration in whether you don't just want to provide some alternative method of entry when it comes to those sorts of promotions. Lots of questions here. I'm going to try to move on so that we're probably going to cover some of these as well. And sorry for my moving through, sometimes scanning through here. So this is actually, we're talking about target audiences as well. And I think we may answer some of these questions here as well. So with target audiences, we get lots of questions about things like, what are the considerations with having a promotion that specifically is offered only to customers, as in trade customers or conferences, employee-only promotions, promotions specifically for a narrow audience as opposed to the general promotion for the general audience. So, with regard to, say, a trade promotion, one that is offered only to your customers, one of the considerations there with any of these sort of non-public promotions is that you may not have all of the states regulating them in quite the same way, in the sense that many of these sweepstakes laws specifically target consumer promotions only, but it's not all of the states. Some of the states simply regulate games of chance and games of skill. And so those requirements that you have rules, and the rules have specific disclosures and the like, as well as the lottery laws, which certainly do not have carve-outs for employee promotions, or don't apply only to consumer promotions. Those do not, those will apply to your employee promotion or your trade promotion. So you certainly need to be concerned with complying with all of those laws. That being said, there may be additional issues that you don't think about with consumer promotions. The first is that when you're structuring a sweepstakes or a contest for your customers, you need to be thinking about the commercial bribery laws. That means that these are the laws that say essentially you can't offer gifts of more than a certain value to your customers, lest they be viewed essentially as bribing, the employees of your customers. Sorry, I left a key word out there. Lest they be viewed as bribing. These laws, at the federal level, that's actually under 2C of the Section 2C of the Robinson-Patman Act. There are state law equivalents. They generally they're very technical, and they often have carve-outs. Most importantly, that they generally have sort of a de minimis exception, which is, if the prize is worth less than a certain amount, then you don't have to worry about them. The other key exception is that if you have the consent of the employer, you don't need to worry about them. So you can either if this is a good customer of yours, you can just say, hey, we want to run this promotion. Is that okay? B, if the other approach is to put language in your rules or in the in the consent to enter, the checkbox when people enter that says, and by doing this, I verify that I have the consent of my employer. So there are ways to deal with that. It's just important to take that into account and take that risk into account when you're structuring this. In terms of employee promotions, there are also, these are your employees. Obviously, it's lower risk to start because how many of your employees are likely to complain about receiving a prize. However, labor and employment law is complicated, and you certainly don't want to get sued. You do need to take into account things like the fact that prizes will be considered compensation. And encouraging your hourly employees to do something that may involve additional hours or working on their time, on their, doing things that, may involve overtime, may raise some complicated issues. To the extent that you've got somebody who, say, is already writing on their job and you're asking them to do more writing in a user-generated content contest, that may raise some complicated issues as well. So you need to be thoughtful about that when you're structuring a promotion that is encouraging your employees to enter. There's also just the basic question about why we exclude employees from sweepstakes in the first place, which I get all the time. And the answer is it's not so much a purely legal issue as it is almost an appearances issue, which is, think what would happen if an employee won the $1 million prize in your sweepstakes, or even a much smaller one. It doesn't look great to the extent that, there's the incentive to sort of award yourself or your friend or your family the prize. That's not great. So that's why you tend to exclude employees. And in fact, this happened years ago there was actually just a movie with Donnie Wahlberg about this, about a McDonald's, the McDonald's game, the Monopoly game, where a group of sort of insiders, it wasn't just the employees, but the contractors who ended up sort of fixing the game. So they got all the good pieces and their family members and friends won. I'm blanking on the name right now, but it's on, I believe, HBO, and it was actually a lot of fun. But this is the type of thing that can happen when you allow employees or contractors to participate in a promotion. And so you need to be careful and thoughtful about whether you want to allow employees to participate. In terms of conferences, you just need to think about the fact that when you ask people to pay for a conference, that can be consideration if you're offering a sweepstakes at the conference. And this is particularly when you advertise the conference up front. So if you're just offering it once people get in, then that's fine. It's people have not, paid for the opportunity. Now, these don't tend to be as high risk as something you advertise nationally to consumers. The attorneys general are not as interested in these. And in fact, it's more a risk, I think, of private litigation, but these are all things you need to consider. Children's are higher risk, promotions targeting children. There are a lot of rules around that. And we could spend a whole long time discussing them. And I'm not going to do that right now because only part of the audience is going to be interested in this. But it's important to remember that the Children's Online Privacy Protection Act requires parental notification and consent, with just a few narrow exceptions that may apply here for single contacts and the like. It's very, very difficult to run anything that requires user-generated content or asks for user-generated content. And there's really almost no way to get around getting around parental involvement. And then there's also requirements from KRU the Children's Advertising Review Unit for plain language disclosures. Additionally, now that we have the California Consumer Privacy Act and the GDPR, you're really worrying about, instead of just 12 and under, you're worried about up to 16 years of age in terms of the age groups and protecting those groups and making sure you have proper consent in terms of using their personal information. So you need to be more thoughtful about that group as well. Now, another interesting issue that I get questions about is discrimination and promotions law and civil rights. This is something that has come up now because there's a lot of people who want to run promotions specifically for a group, whether it's women or for minorities or the like. What's complicated here is there are state civil rights laws that prohibit discrimination, and they may and have been used to reach discrimination in sweepstakes and promotions laws, or rather as sweepstakes and promotions that are perceived to separate the groups on the basis of race or gender or some of the other categories. And while at the federal level, this is more difficult, some of the state laws do not, are really use more of a per se just sort of test. There are some states which will say, okay, this promotion has discrimination, it violates the law on its face. Others do more of a balancing test. Well, they look at harm versus the rights protected. So there's the example of California and the Unruh Act, which says all persons within the jurisdiction of this state are equal, no matter what their sex, race, color, religion, ancestry, national origin, medical condition, genetic information, marital status, sexual orientation, and they're entitled to full and equal accommodations. So you've got the language here. There are several cases in California where the courts have found that something like a Ladies' Day discount or a Mother's Day tote bag giveaway was or was not prohibited. Similarly, there was a challenge to the last Wonder Woman movie, not 1984, which those who saw it in their homes generally, but the first recent one, where a Texas movie theater had a woman's only showing, and somebody tried to challenge that showing as in violation of the Texas civil rights law. In that case, actually, it ended up sort of being laughed out of existence. Even the mayor of Austin sort of said this is ridiculous and should not go forward, and it got a lot of press and the like. And so I think there was another situation where there was a men's only ad for razors, and in the end that ended up getting changed to be sort of more generally focused. So you get these periodic challenges to promotions and the like that are targeted typically on the basis of sex, but there are a number of different protected categories, and the laws are there, and in various states can be used almost per se to challenge these. And so it's important to be aware of that. That being said, in the current environment, it's sort of a risk calculation as to what you think the risk of challenge is and what the public reaction to such a challenge is going to be. I think that risk calculation is changing. And additionally, there are ways to draft promotions where everybody can enter, but perhaps there's more of a target to different audiences versus others. So it's important to be thoughtful about the fact that these laws do exist, and take them into account in designing your promotions. So modifications and termination clauses. This is another question that's come up, particularly in sort of the age of COVID-19. There are a lot of people who in March or April were dealing with promotions that were in some way dependent on the occurrence of an event, and suddenly found themselves in a difficult place. Either the prize was focused on somebody attending an event, or the promotion itself was going to be launched at an event and suddenly the event was not happening, or for all other sorts of reasons. We typically draft promotions rules or sweepstakes or contest rules with some sort of modification or cancellation clause in it. And that provides substantial latitude for sponsors to make decisions to modify or cancel promotions. But in general, under both the sweepstakes laws and the sort of general unfair and deceptive trade practices laws, modification is always viewed as a remedy of last resort. And there are numerous cases about this. Often in private litigation, where somebody says there was a modification, it was unfair to me. You can find long lists of cases, and in fact, we researched this considerably in the spring. Additionally, there was a time period where New York would reject any set of rules that was submitted to it for filing, for registration, that it viewed as having too broad a modification clause. So this is something the states take seriously as well. In general, you do not want to modify unless there is a situation where there is some sort of impossibility, fraud, true impracticability or frustration of purpose, which is something that you see in force majeure as well, where you really cannot do anything but modify. The problem being that if you modify sweepstakes rules and they are viewed as unfair to the people who have already entered, then you may have a situation where the people who have already entered can sue, or a regulator can sue and say, this was deceptive and unfair. So it's really something that is a remedy of last resort. Additionally, the other important clause that has been exercised much more frequently recently, as I'm sure you all know, is force majeure. Force majeure, of course, is supposed to free parties from liability when there are unanticipated, unforeseeable, supervening events or circumstances beyond the control of parties. And so because of COVID-19, we've got many, many cases going through the courts right now, in particular in the insurance litigation context, litigating exactly what situations force majeure can be used in the COVID-19 context. And again, also with, impracticability and frustration of purpose, when force majeure, maybe the clauses that were in place prior to COVID-19 often didn't reference things like pandemic or epidemic or the like. And so, there's litigation over the fact that these contracts just can't be carried out now because of COVID-19. So generally, we're all now modifying our sweepstakes rules to specifically reference not just act of God or terrorist events or various other reasons why, maybe you can't have an event or award a prize, but also pandemic or epidemic. So now, user-generated content contests. There are various types. But of course, contests are the most popular. You can also get sort of just plain old requests for content where a prize is not awarded. And so, that's something else. You do need terms and conditions for all of these. And so, I went back somehow. Sorry about that. So, a lot of this, you need clear terms and conditions. And we'll talk a little bit about what goes in that. You also need to be thinking about what are the risks inherent in asking the public for content. You really need to have a request that is not too open ended, because while you can have really creative entries, you can end up with what happened with the New York Yankees farm team, which is they asked for people to name their team, and they ended up with and then for others to vote on it, and they ended up with a baseball team called the Pizza Rats, which I actually really personally think is a great New York name. But if people remember the rat who was filmed spending his afternoon dragging a piece of pizza up a flight of stairs, I think the runner-up was the rock pigeons. So, you got to watch out for what a crowd is going to do when they're allowed to vote on what your baseball team is going to be called for the following season. And that's sort of a lesson in voting contests. But in any case, you also have to watch out for things like intellectual property and all sorts of other issues. So there are lots of similar issues to sweepstakes and contests to keep in mind with UGC promotions. The great thing about them is that the absence of chance means that consideration can be required, except in a few states, like the ones listed here, that prohibit a purchase or payment requirement, even in skill contests. That's generally interesting when you have something like a contest that asks for a product review or a best result. And so it's something that to think about, if it's something where you want to ask for people, to use the product, can you just ask them to, come up with a creative something using like the marketing or I'm sorry, I'm blanking, the logo or something like that. But that's something you need to think about. Also, Arizona can require registration for contests where a purchase is required. So you may need to register. You also need clear entry guidelines, guidelines as to what is appropriate for content, and then moderation of the entries, particularly if you're planning on posting them online before they're judged. Judging and voting present special concerns. As you can tell, voting can get out of control, with the Pizza Rats being the, exhibit 1 there. But there's also, you need to make sure that your judges have expertise and preferably independence as well. And you need clear winner selection guidelines, both to guide the judges and also to guide entrants as they submit their entries as to what's appropriate or not. In terms of voters, there's always the possibility of voter fraud. And there's also the question still unresolved as to whether a voting contest is even really a skill contest. But in that case, there's really merits to a 2-step winner selection process. It sort of eliminates that question, and it also eliminates the issue, well, let's call it the Pizza Rat issue, in the sense that it gives you some modicum of control over who the winner is. You can either have the judges select a pool from which the voters can select a winner, or you can have the voting pool select a group of top entries from which the judges can select the final winner. There's also the fact that if you're going to have people posting online, they need to include disclosure, compliant with the FTC endorsements guidelines, which we'll talk about in a second. You need to comply with third-party platform rules and also IP considerations, which we'll talk about right now. The copyright and trademark rules. I think I may have just skipped a slide. Yeah, third-party rights and contests. The problem here is that users own any original content. Well, that's not true. While users may own the original content they post on social media, you as the sponsor do not own their content per se. You have to get the rights through the rules to your sweepstakes or contest and consent from the users. So things like copyright to videos or images that they're posting, drawings or music, issues like trademark and logos, third-party logos or the like, or the right of publicity, people's names, voices, likenesses, third parties, they all need to, you need to get the rights to all of the above. One way to do this is ideally to have people submit their content through a website or an app and obtain a click wrap license or agreement to the rules that has certain licenses in it. You're still going to have that problem, though, of any third-party content that your entrants don't have the rights to that may be sitting in their entries. So you've got to be thoughtful about that and either A, ask them to exclude it, or B, ask them to get licenses from people. Obviously, the more, and include those for you, and obviously that's the more complex route. We're gonna speed up a little bit because we went a little slowly answering questions in the beginning, and so now we're going to run a little short. So in terms of the types of issues here, we've also, the right of publicity is probably the most complicated issue, where you've got third parties who are almost inevitably appearing in content that's being submitted. This can be very expensive. Individuals have the right to publicity, whether they're celebrities or not. And so, you know, you need to get the permission in writing eventually to use any person's image, name, etc. For to reuse it. So, you know, you either can tell people not to include third parties, have them say, yes, I have the right and I'm prepared to provide, you know, their release or permissions in writing, or actually have them upload it. But it's all sort of on a risk tolerance spectrum as to how you feel about that. And so you need to think about that as you write your rules so you don't end up caught out later, particularly if you're going to want to repost this stuff in the future. So in terms of, this sort of goes back to it, how do you get consent to reuse user-generated content? If you want to do this, you know, as I said, it's easiest on if you have a nice website and you have them submit it. If you're doing something on Facebook or Twitter or the like, you know, can you have somebody just respond yes to something like, oh, I love this photo. Do you approve of us featuring it? That's really overbroad. So what you need to do is do something like make a specific request and then attach and link some sort of release or terms and ask for a clear signifier of consent, whether it's with a hashtag or 2 hashtags that are very unique so that you don't necessarily inadvertently capture photos. You can then hyperlink those terms and conditions either in your profile or on a website, explaining what is and or is not acceptable content, and moderate your feed to make sure that everything submitted is compliant. So I think we've sort of covered this. So I'm going to go. The next thing is the social media terms themselves. It's important to understand that each network has its own set of rules and usage guidelines that are often can be quite strict for sweepstakes and contests. We've talked about how the IP rights grant doesn't necessarily give you all the rights you need. You don't even necessarily get the right to contact users without getting sort of IDEA M and the like, without getting permission in your rules. The important thing is that if you violate these rules, your page or promotion may be torn down or taken down rather. So you need to be thinking about this and have, a sweepstakes or promotion that is compliant. So just to go over the most, the strictest, and then there are other slides here about the others. Facebook says you need specific releases, and this is common for all of these platforms. But what Facebook says that people don't always get is that you can't do what's called like getting a promotion, which is saying somebody must like your page. And you can't ask people to share content to their personal pages or timelines, or share content or tag themselves in content where they do not appear. You're also not allowed to share on friends' timelines or tag their friends in content where they don't appear. That being said, there's lots they can do, including liking comments or pictures, announcing winners, or the like. So that's, it is a very effective platform, as is Instagram, which has similar rules, although it's slightly different. We're getting lots of questions now about using Facebook and Instagram stories for promotions. And it's important to remember, like, sort of the limitations and the like, which is that Facebook and Instagram stories just don't stay up forever. So it's going to be hard, while they can be used as tools in promotions, it's not necessarily where you want the whole body of the promotion to be. You also are going to have to either find a way to sort of post abbreviated rules or link to full rules, which is a more difficult proposition. With Instagram, of course, in general, the problem is that it's more static and you can't necessarily have live links. But what you can do is you can post the official rules via static link and then reference to a link in your bio, or you can also put your abbreviated rules in static form in a comment below and then reference back to a link in the bio. So skipping forward, a reminder that the FTC endorsements rule requires that for any sweepstakes or contests, you must require that sweepstakes entrants include a disclosure in their entry, or tweet or post, that they are entering in a sweepstakes or contest, because the FTC believes that even the opportunity to win is a material connection under the FTC's endorsements and testimonials rules. So something like, hashtag Venable Sweepstakes or hashtag contest entry. To date, something like a or something like that is not something that requires a disclosure, but we're still keeping an eye on that. We're getting towards the end of time. I'm going to keep going. for people who want to hang in there, but I realize some of you may need to leave. Sorry that this is run a little long. It's a new presentation. So sometimes you run off timing on that, particularly when you're entering, when you're answering questions rather. So my apologies, but this will be recorded. And as I said, I will be answering some questions as well, because we're getting lots of questions. So refer a friend and can spam. You do need to worry about can spam. I mean, we all think about can spam as the same old, but the thing about can spam is that can spam is triggered with refer a friend promotions because you're incentivizing behavior. And so essentially the way it works is this. Prize promotions with the refer a friend component, if I am sending something to my friend, I am essentially, when you incentivize me to send something to my friend, you are incentivizing behavior, and therefore we're triggering can spam. The email that is sent to my friend has to comply with can spam. The part about false header information, misleading subject lines, having an unsubscribe is pretty easy. The part about scrubbing the email that's being sent against your do not email list is a little more complicated. And the part about determining whether it's in fact me as the person who's sending the email in this hypothetical, or the company as the sponsor of the sweepstakes who's sending the email is a little more complicated sometimes as well. So you do need to look deeply at what you're doing to try to determine whether it is in fact you as the sponsor of the promotion that's sending the email, or me as the person who's entering, who's sending that email in order to get the extra entry. The other thing to consider is that Facebook and some of the other platforms, Twitter, Snapchat, say no spammy behavior. So you need to watch out for these promotions sometimes, because you may end up violating the platform rules and getting shut down if you are trying to encourage with this type of spammy behavior with this kind of refer a friend promotion. There's actually an opinion out there, never duplicated, that says that even online, rather social media promotions are covered by can spam. It's very difficult to apply that sometimes in the current iteration of Facebook. So we haven't really sort of seen that, other than being thoughtful, frankly, about how your promotions on social media are going to comply with the social media promotions. But keep that in mind, that decision exists. Mobile marketing and text promotions. If you are doing a promotion that involves text messaging, keep in mind that under the TCPA, you must obtain express prior written authorization to send messages via text message, to send messages to consumers. So there are private class actions out there that involve allegations that a retailer, a promotion sponsor sent unauthorized text messages in connection with promotional sweepstakes. So, this is something you need to make sure. These are big settlements. When you get settlements in these text messaging class actions, you need to make sure that you are complying in terms of getting consent to text people, following the rules for signing people up, and then making sure that you're following all the rules when it comes to text messaging. It's just something to keep in mind. We talked also about, whether text messages are a consideration. So you do want to be thoughtful about that. Additionally, another thing to keep in mind is that you want to make sure that all the disclosures that you're making in a text promotion are mobile optimized. The FTC has provided guidance here. There's also mobile privacy guidelines. The Instagram influencer guidelines provided, the guidelines that you must make key disclosures before the click for more. So, and then you've got things like I guess it's CTIA now rather than MMA, but trade association guidelines that include industry protocols for mobile sweepstakes. And so you need to sort of line up how you're doing this in terms of consent and sign up and how you let people opt out and the like to make sure that you've got everything buttoned up in running your mobile sweepstakes. We've done this, so I'm going to skip forward. Surprise and delights. You get lots of people now who come to you and say, but I don't need terms and conditions. This is a surprise and delight. The idea being with a surprise and delight that you simply surprise one of your most devoted consumers with a prize, and then they talk about it and give you great publicity. But because you have not promoted it in advance, you don't need terms and conditions or disclosures because you never advertised it. And if, in fact, a surprise and delight works that way, you do not need terms and conditions. But it's hard for marketing to not promote because that's what they do. Marketers got to market. And so if, in fact, people promote this, then you may well trigger the need to have terms and conditions. The gray zone is when you start doing something like, we're going to have a surprise for you. Keep an eye out here, or that sort of thing. And so I tend to draw the line at a place like, if you're telling people that there's a prize, there's going to be a prize coming, or versus something's coming, watch this space. And it's a judgment call as to, when you cross that line, and there's actually a call to action for a sweepstakes. I see the question, can you have global surprise and delights? We'll talk a little bit about international, but I have to tell you that I think that makes what is already a gray area call even more gray, because this is still sitting really seriously in a gray area. I think the other gray area judgment call here is when you start to have repeated surprise and delights. When does a surprise no longer a surprise? Because you come to a point where people start to expect the surprise every other week. And so that's a tough call. And in fact, in the early days, Facebook explicitly said, to me, this is not like a policy or anything, that we don't know. There may be a point where we don't let someone keep running these because they are so regular that people actually just expect them. And so that's something else to take into account. If people are running surprise and delights all the time, then you may get people hanging around your Facebook page or whatever, waiting for the surprise and delight. But in terms of what, avoid pre-announcement. And then the other thing is then the people who get the surprises, you may want to consider giving people clear guidelines about maybe an embargo on when to post if there's a time you don't want them to post. if you're going to award more of these or the like. And then also, you may want to ask them to disclose, because of the FTC endorsements and testimonials rule, that they got them from you, and, make a compliant disclosure. Also, if it's a very valuable prize, you may want to, or if it's a trip or the like, you may want to get a release, publicity liability release. If you want to use their thank you, the publicity release. So things to think about there. Charitable promotions. Everybody's doing a commercial co-venture right now. So these are regulated under the laws of 26 states. If there's some sort of purchase and then a donation, buy this and we'll give 5% of your purchase or the like, then there's clearly a commercial co-venture, which may trigger registration and bonding requirements, a requirement for a written contract, specific disclosures, accounting disclosures, and the like. So something to keep in mind. But then there's also charitable sweepstakes and raffles and auctions, which are growing increasingly popular. We see these charitable sweepstakes sites, which a lot of our commercial clients are getting involved with as well. And the thing to keep in mind with that is that there are the raffle requirements, which are extremely strict and only nonprofits can do as an exception to the lottery laws. And then there are the sweepstakes laws, which are, of course, we've been talking about this whole time, but are more complicated with nonprofits, although they're more and more popular, because there's actually not as clear an exception when these sweepstakes are not run in connection with the sale of a consumer products and service. So these charitable sweepstakes sites are a little more complicated in the analysis, with the exception of Florida, which actually has an explicit exception for nonprofit sweepstakes as well. And so there have been a couple of settlements in California with the California Attorney General involving these charitable sweepstakes sites that were focused on two issues. The first was making sure their disclosures were sufficiently clear and conspicuous. The second issue was making sure that they were registered as professional fundraisers under the professional fundraiser laws. And so it's important to make sure, if you're working with them, that your disclosures are sufficiently clear and conspicuous, that these sites have everything buttoned up properly. And so, do good while doing good compliantly. The other thing is, of course, the auctions and the charitable auctions. And it's just important to keep in mind that there are laws regulating state, or there are state auctioneer laws as well. So take those into account as well. Getting towards the end, international considerations. When you're talking about something that spans multiple jurisdictions, there's the question of how do you address compliance and risk there. The sweepstakes laws and the online gaming laws can vary very drastically. Issues like whether you can give away a cash award or specific types of prizes. Countries like Brazil prohibit those altogether. Registration. Many states require registration, or many countries rather require registration of sweepstakes. You've got a few listed there. A few even require registration of contests as well. Many countries require translation and disclosures in particular languages. The fact that there are countries with more stringent privacy laws, of course, is well known, and you have to take that into account. And there are even some countries that require that you have separate prizes for residents of their countries, so Spain or Italy. And so it's very difficult to run multi-jurisdictional sweepstakes and contests. And so it's always a good idea to check with counsel in those countries. Venable is a member of a group called the Global Advertising Lawyers Alliance that has lawyers in, I think it's about 90 countries now. And so we frequently will work coordinating counsel in multiple countries to do this. And we're always happy to coordinate or to give referrals or whatever works. If you are thinking about doing this, but it is important to remember that it's not just the same as the US. Promotions gone wrong. There are a million of them. And we've talked about so many. We're out of time though, so I'm gonna let you off the hook with the scare stories. Although actually I am gonna talk about this one very quickly. The situation with this one was a very common one, which is basically that this was Beatrice Food, a food conglomerate called Beatrice, which had a scratch-off contest where players who correctly scratched off the correct number of touchdowns and field goals in the game won. The odds were supposed to be 1,000,000 to 1, but somebody cracked the pattern and scratched off 4,018 winning entries totaling over $16 million. And when he approached Beatrice, offering to show them how he did it, the company just canceled the game 2 weeks before the ending date. And then, of course, the company was sued for violating their terms. Beatrice lost. They had to pay $2 million to participants and settled with this very clever player who broke the code. So these can go wrong big. This is an example of just violating your own terms by trying to modify them. So it is an example of don't modify your terms. But there are, a million things where things go wrong. And sweepstakes is a complicated game. So it's important to proceed with care. You don't get unlimited power over things just because, you're giving away money, and why shouldn't people be happy? But so, it's a lot of fun to do these, but it is one of those super picky areas. So, thanks for listening, and sorry to have run over and taken extra time, but we will hopefully talk soon. I will try to answer all of your questions, and have a good afternoon.